Okay, so welcome Jonathan Feingold to 10-6 Life Factors. We're here to understand his research and any information that he can provide to us about the concept of diversity and other areas that he has looked into. Thank you for being here, Jonathan.
Thank you for having me.
Okay, so tell us about yourself.
So I am an associate professor of law at Boston University School of Law. My research tends to focus on how anti-discrimination laws, so laws that are ostensibly designed to prevent racial discrimination, in practice or in function, actually tend to entrench racial inequality, as opposed to move us closer towards a society that is defined by racial equality. And it's sort of counterintuitive because most people would presume that laws that prevent discrimination move us closer to equality, but it turns out oftentimes they don't. And specific areas of focus for me are affirmative action and other forms of race-conscious remedies. And then I think about diversity in a lot of different ways, and then picking off different aspects of education law as well.
And there's so many areas to research. There's a lot of research actually on this topic. But the curiosity for me was, you're actually pointing us and say, wait a minute, none of this is really getting closer to resolving any of some of the issues that we're having. So why the topic of diversity or anything that has to do with racial understanding of race and racism in institutions?
So I come out of sort of a academic trajectory where one of the core questions that I was asking is, why is it that 50 years or so after the United States transitioned from what had previously been essentially American apartheid, so Jim Crow, a formally racially segregated society, to one that was formally equal? Why is it that the transition from formal inequality to formal equality actually failed to alter in material ways a lot of the sort of actual substantive realities of people? Or to put it differently, why is it that laws prohibiting discrimination haven't actually been able to lead us to a society that is defined by equality? Because if you look at any number of metrics, whether it's educational outcomes, whether it's health, whether it's just access to good drinking water and healthy air, we know that an individual's racial identity or the racial identity of the community that they live in so often correlates with who has access to what we would think of as private or public goods and who doesn't, notwithstanding the fact that the law says we can't discriminate. And so much of my research is just motivated by this troubling observation that laws that prohibit discrimination have been insufficient to actually create a racially just, racially equal society. And so that's sort of the observation that is motivating my research. And I think it's an observation that really re-entered the sort of mainstream conversations in the summer of 2020, in the summer of protests, where there was global uprising for racial justice that was maybe triggered by the murders of George Floyd and Breonna Taylor, when we were all asking ourselves, maybe not everyone, a lot of people had been asking, but I think more people were just explicitly asking. We think of ourselves in the United States as a multiracial democracy. But if we actually take a clear-eyed look at ourselves, maybe that's not all that accurate. We think that we're a country in which your individual effort, your quote-unquote merit, determines whether or not you succeed. But if we take a hard look at ourselves, we know that's not true. We know that the zip code you're born in, we know that your parents' wealth, their level of academic achievement, like that is what's going to predict whether a kid or a student is able to sort of climb the economic or socioeconomic ladder. And so we think of ourselves as a meritocracy, but we're not. And so my research really looks at how the law and narratives embedded in the law essentially entrench inequality, even when we tend to, think of ourselves as in different respects.
And so you're the scholar, you know, you're looking at this. What is it? What are the driving factors then behind all of this in terms of the fact that the law is in place about equality, to protect against discrimination and the distribution of resources, whether or not it's federal funding, state funding, and so on. What is it then that, or who is causing all this shift in, or I don't know what the base was, I guess from the shift back to inequality then, I guess, because the attempts were there to create more adequate resources and to allow this to be distributed fairly. So who is causing this then?
So it's a really good question and a lot of answers. So let me just sort of pick out a couple things. One is that, so we know that many laws prohibit quote unquote discrimination, but that term could mean any number of things. And so after you have a law that is passed, so for instance, Title VII, which bars discrimination in employment settings, or Title VI, which bars discrimination within any institution that receives federal financial assistance, which is most schools, K through 12 and higher ed in the country. If the word discrimination appears in that statute, that doesn't determine in itself what's actually prohibited. So after legislation is passed, then you see fights in court over, well, what does discrimination mean? And you can have a really broad definition of discrimination. And so you could imagine discrimination means any policy that has an unjustifiable disparate impact on different groups, sort of understood by race. That's relatively broad, but certainly a plausible understanding of what discrimination means.
Right.
You could also have a much narrower definition of discrimination, where discrimination is only when an identifiable individual treats some other identifiable individual differently because of their race. And really the goal there is to get into the mind of an individual perpetrator and ask the question, well, did that perpetrator treat someone badly intentionally? And that is a very narrow way to conceptualize discrimination. Now, it turns out that in part because for the past 50 years, at a minimum, the majority of the US Supreme Court has been conservative. Mm-hmm. And so justices on the Supreme Court have historically adopted and preferred a far narrower conceptualization of what discrimination means. And so what that means is that legally you are only prohibiting, certain sorts of conduct, and at the same time insulating from legal critique a whole number of policies that might not be motivated by a desire to maintain inequality, but are quite effective at doing so. And related to this is just, a fight over, well, what is racism? Because most people in the United States would agree, yes, racism is bad. It's even in today's politics, it's very hard to find someone who will say, no, I'm actually for racism. But once you have a social shift, so imagine it's the 1960s, it's been 10 years since Brown v. Board of Education. For the past decade, much of the South, though not just the South, but much of the South is just vociferously protesting Brown, trying to take different steps to avoid having to integrate institutions. But then there's sort of this cultural shift in the 1960s that includes the passage of really critical civil rights legislation like Title VI and Title VII that I mentioned, major voting rights legislation, major fair housing legislation, but also the shift that, racism is bad. And so if you are someone, or if you're an organization, and you actually prefer the pre-civil rights order, so you actually liked American apartheid, but you know that Americans generally now think that racism is bad. Well, the fight then is not over whether racism is good or bad, it's over, well, what constitutes racism? And so you see a clear shift in the mid to late 60s after institutions begin to start employing arguably quite modest efforts to become more inclusive, and doing it in a number of ways, but including taking the racial identity or the gender identity of individual applicants into account. So like you can imagine a fire department, historically overwhelmingly white, overwhelmingly male, for all sorts of reasons, institutional culture, formal practice, informal practice. But then if the law says you have to stop discriminating on the basis of race, on the basis of gender, and there are affirmative obligations to do so, then it means an institution's fire departments are going to be forced to take steps to become more inclusive. And so you begin to see both court order, but also voluntary efforts on the part of municipal organizations, fire departments, police departments, to try to become more inclusive. But those efforts are always contested. And the contestation
By whom?
By individuals and entities who prefer the prevailing order, who actually prefer fire departments that are overwhelmingly male, overwhelmingly white, don't think that people of color or women should be in these organizations. So if that is your political agenda, it's going to be strategic to sort of say, okay, well, how can we reframe civil rights remedies as themselves a threat to civil rights? And so even in the 1960s, you begin to see the sort of rhetoric that is now commonplace that would describe sort of an affirmative effort on the part of a fire department to become more inclusive for women of any race or people of color, to describe that as preferential, as a deviation from merit, as itself sexist or racist. And so even in the 1960s, and you can actually track this back even farther to the 1880s, but there is this rhetorical move where individuals, entities who actually preferred that pre-civil rights order start describing and characterizing civil rights remedies as sexist, as racist. And it's like, well, how could that be? And it's because there's this sort of rhetorical move where the entities that prefer the pre-civil rights racial order say, well, you know what it means to be racist? It means seeing someone's race and acting and attending to a racial identity, or seeing someone's gender and treating two people differently because of their gender. And now you see sort of, and scholars will refer to this as colorblindness. It's the view, it's the sort of two claims, one empirical or descriptive claim about how the world works, then one moral. Empirical claim is that race doesn't matter. Race is just skin color. And so to the extent different people end up in different places, to the extent racial disparities exist, it might have to do with something, but race isn't the cause. Racism isn't the cause.
Right.
And therefore, it's wrong morally to view the world through a racial lens or through a gendered lens. And so that rhetoric now you see on full blast in response to, really as part of the narrative backlash to the summer of 2020, where you had institutions across the country saying, wow, we actually have not interrogated all the ways in which we as an institution or we as an organization reproduce racial inequality. We've just not been super thoughtful about it. And we should be, because if we're not being proactive, it's likely that we're going to reinforce or reproduce and what was an explicitly racist past. And if you don't like that agenda, if you prefer the status quo is fine, then you want to discredit efforts to reshape the status quo. And so that's where we saw by the fall of 2020, you saw folks on the right, the political right, labeling anti-racism as racist. And the move was to say, well, they're racist because they see the world through race.
Right. So I guess then from how you describe it, it would be a safe and a fair statement that mainly white males are actually the driving force behind disrupting any progress towards equality in any of those categories that you mentioned. And because if you say, for example, higher education institutions, are forced now to assess their diversity statement, we know who run these institutions. If you're talking about even the local firehouse, if there's any lawsuit against them, we know who the chief of the fire chief is. And he may not necessarily want this. And sometimes they have no choice but to pretend or appear to participate. So the question then, and that's why some of the reasons why this concept of anti-racism now has come up. So the question now would be, you mentioned where everything is drifting towards the courts for them to make the decision, and changing the definition of the constructs of race, racism, discrimination, and so on, and kind of shift it into a way that confuses many of us, even people at the higher level. So talk about there's an article that you did, the eyes wide open. I did not read it, I glanced it, so I'm going to be honest. So what you're telling me is going to be new to me. You said, what social science can tell us about the Supreme Court's use of social science? Help us make sense of it as based on the arguments that you just presented, because everything is being shifted. The policies that Congress created is being shifted, and the Supreme Court will have to make decision on it. So help us understand how social science comes in all of this, and the confusion in terms of this concept of objectivity or subjectivity. Go ahead.
Yeah, so I guess, so first, just with respect to sort of the presumption that oftentimes the individuals who are going to be opposed to more racially egalitarian policies might be individuals who are male and themselves racialized as white. I think that's likely true, but certainly we also see a lot of examples where you have institutions that are sort of run by a more diverse, racially gendered group of people, and still are not necessarily adopting policies that are going to be more sort of racially just. And so I think empirically it's likely correct, especially just given the history. But also at times you have people of all racial identities who are also working towards projects of racial equality. Mm-hmm. And then just another important sort of note is that the group, the demographic that has likely benefited the most from affirmative action type policies in the history of the country are women who are racialized as white, in part because it's a huge demographic that was locked out of the workforce, and the one that was, for different reasons, most able to benefit from many of the early inclusionary-oriented policies.
Yes.
But if you just look again demographically, women racialized as white often are antagonistic towards affirmative action, because many of the right-wing entities that were opposed to any civil rights remedy from the beginning early on started framing affirmative action as unfair to men, particularly men racialized as white. And so this led women, white women in particular, to end up occupying this sort of awkward position where their group actually has benefited as much as, if not more than, any other group from these policies. But then this narrative sort of saturates, just public discourse or public conversation that leads those same women to perceive that these policies that are opening the door to many are somehow harming their husbands and sons in a way that can, mobilize a group antagonistically or in opposition to a policy that actually benefits them. But then you ask, okay, so what about social science? And what is it that I have to say about social science? So here's one way to think about it. Someone like Governor DeSantis, I'm just going to try to make things concrete because I think sometimes it can be helpful. So he's on the record, and many of his associates are on the record of denying that systemic injustice is real. They just say like systemic racism, not real. Systemic injustice, not real. They don't deny that significant racial disparities exist across every, essentially every relevant domain in American society, whether it's who gets arrested, whether it's who is subject to police violence, whether it's who is subject to pollution, health outcomes. They don't deny racial disparities exist. They don't deny that racial inequality exists, but their claim is that there's nothing morally objectionable about that inequality. And underlying that is an empirical claim that the world is fair and everyone essentially just gets their just rewards. Because if you succeed, it's because you worked harder. If you were pulled over more often, it's because you're doing something wrong. It's not because your racial identity or race is functioning in ways that acts as a headwind for some and a tailwind for others. And so what does this have to do with social science? Well, it's frequent throughout our lives that we encounter evidence of racial inequality, but we don't always have explicit conversations about what caused that inequality. And you can essentially draw there's sort of two competing hypotheses. One is that inequality is simply the product of different groups with different values and different behavior. Some groups are just more committed to education, and so that's why they succeed and others are not. That is a theory. Another theory is, and I'm being somewhat reductionist here, but racism. It's that as a function of racism in its many forms, structural, individual, differently situate individuals and groups in ways that almost predetermine outcomes. That has nothing to do with differences in values or cultures or work ethic, but literally you have this thing called race that's working in tandem with other social drivers like wealth and socioeconomic status, but that is either functioning as a conveyor belt for some, moving them forward, and just a pit for others where you can't actually get out. And so social science can be really interesting because it can help us prove which empirical theory is correct. Is it true that these different groups, that there's actually some like cultural difference, which it's really important to know. Culture arguments emerged after arguments that attributed racial difference to biology became socially unacceptable. That's when cultural arguments rose up. And social science overwhelmingly confirms, which should not be a surprise, that the drivers of racial inequality that existed in 1940, in 1960, in 1980, in 2023 remain primarily this thing that we call racism, which again can mean many different things. So you have scholars like Dedrick Williams at the University of Tennessee, who his work is is focused on teasing out, okay, so we say racism causes racial inequality. Well, really, what does that mean? And one thing that he shows is that, well, you can have families that are similarly situated in like all material respects. There's no variable there that should be predicting different outcomes except for their racial identity. And that is still leading to different outcomes, which suggests that there's something structural about the way that racism is working. But then you might say, okay, so how does social science work on the Supreme Court? Many Supreme Court justices, like many Americans, have lay theories about why racial inequality exists. So you can think of it as our racial common sense. We don't explicitly articulate it, but if someone says, well, why is this school overrepresented by white students? They might be like, I guess, because they're more prepared, because they've got more of this quote unquote merit. And then so you are going to, if that is your underlying hypothesis, that at a place like Harvard is overrepresented by white students and wealthy white students because, those students just, I guess are the quote unquote best and brightest, then social science tells us that you're going to be more likely to accept empirical evidence that supports that hypothesis. And you're going to be less likely to be even interested in empirical evidence that cuts against it. And it turns out that there's really, really compelling evidence that wealthy white students at Harvard are not overrepresented because they are quote unquote the best and brightest. In the litigation that is currently pending, in which plaintiffs sued Harvard for employing race in their admissions process, one of the expert witnesses or the party suing Harvard suggests that as much as 33% of Harvard's white student body is only there because they're the beneficiary of legacy type preferences. And that if those students, like 1,600 students in a 5-year period, if they were subjected to the same standards as everyone else, they wouldn't be there. Now, that's empirical evidence that undercuts
legacy admission. Just define that, meaning they inherited what their parents or grandparents and so on. Yes?
Yeah, so a legacy policy generally is one that gives an admissions preference to someone who has a family member, like a parent who attended that institution.
Right.
And so at a place like Harvard, historically, Harvard's been overwhelmingly white. And so you know that just as a matter of disparate impact, if you are favoring legacies, you're going to be favoring white students. But also think at a place like the University of North Carolina, which also, it has a far less impactful legacy preference. But University of North Carolina was founded, I think, 1791. That might not be quite right, but I think pre-19th century. Even after Brown v. Board of Education, University of North Carolina still had a policy that formally excluded Black students. It took lawsuits after Brown v. Board to make UNC drop that policy. And then for the next 25 years, essentially, UNC fought federal efforts to actually force the school to comply with basic anti-discrimination law. And so for the for the large majority of UNC's history, it was either explicitly or not explicitly, but still intentionally excluding Black students. And so if you are then going to employ a legacy preference, that is, maybe on its face, quote unquote, colorblind, because anyone who is, ostensibly legacy can benefit. But in an institution where its almost entire history is one that was defined by racial exclusion, it's a racial preference for white students in anything other than name.
You said something key there. You said something about racial common sense. I think he's a law professor, Haney Lopez. I don't know if you've read his.
Oh yeah.
And he did a research where he dug up a whole bunch of Supreme Court cases from back in the 1800s after the slaves were freed and everybody was they were having this race restrictions and classifications. People were being basically deported or restricted from coming in. And he said what his findings were, that the Supreme Court was relying on this same, racial common sense. Like, well, everybody know that people from the Philippines are not white, so that is them relying on social science. But you're saying that if anything, they would reject that and say they're not. If anything, they're relying mainly on the law, the interpretation of the law in an objective sense. So could you talk more about that?
Yeah, so I love so much that you brought up Ian Haney Lopez's work. And so his scholarship is part of a broader set of academic work that is just trying to make sense of the insight that race is a social construct. So I think many of us can say pretty easily, yeah, race is a social construct. But the question is, well, what does that even mean? And so what Ian Haney Lopez traced is that, so there were a number of contexts in which either the Supreme Court or other courts we're faced with answering the question, what racial identity does this person have? Or put differently, which category do we put them in? And what Haney Lopez and others have identified is that the Supreme Court, that there's no coherence to the Supreme Court, for example, and how the Supreme Court has characterized people on the basis of race, except that oftentimes there is a socio-political reason why the Supreme Court or other entities of power and esteem categorize in different sorts of ways. And so let me make it even more concrete. So imagine there is a law that only grants citizenship to quote unquote Caucasians.
Right.
And so first of all, if we're thinking about race being a social construct, well, this category Caucasian or white or whatever it is, that's socially constructed. There's nothing that precedes our culture where those categories are inherently the categories. But then another question is, okay, well, what determines who gets into which category? So again, you have this law that says you can only be a citizen if you are Caucasian. And then you have someone who is of Indian ancestry. Say they were born in like the country India, or their parents were and they were born in the US, or let's say someone from Japan. And the Supreme Court has never actually confronted the question of, well, what is the racial identity of these individuals? And you have a society in which there is not yet a, clear sort of common sense, just intuition about what racial category these people fall into. And you have people who are from these places who are saying, well, I am white and I am white. And it's like, well, what is the evidence that they're going to look to? Well, they might say, well, look at my skin. My complexion is very white. Or look at the language I speak at home. Or let's look at the ethnographers or the anthropologists. Like they actually place me in the category Caucasian. And so what Haney Lopez then reveals is that, well, sometimes the Supreme Court, in order to exclude groups from the category white, because oftentimes the move is excluding different groups from the category white. Because if whiteness is an exclusive category, then it becomes more valuable. Sometimes the Supreme Court will say, well, you got to look at the social science. You got to look at the anthropologists. An anthropologist would never suggest that someone from Japan could be white, even if maybe phenotypically in some ways they share a similar skin tone. But then when it comes to someone from India, the Supreme Court said, okay, well, the anthropologists might group this together. But if you were to go to a bar, if you were to go to the coffee shop and ask someone, they'd be like, of course, that person is in a different racial category. And so that's a moment in which the Supreme Court is not relying on the social science, but it's just the common sense. And the main, or one of the sort of key insights that Ian Haney Lopez and others are just trying to surface is this thing we call race, is in a sense super sort of intuitive, but it's also very elusive. And even both the categories and then the rules that determine who gets into one is the product of human actors making decisions and courts. And so the law is itself actually constructing what race is. And rarely is the Supreme Court coherent or necessarily equipped in any meaningful way to with any sort of expertise and nuance and thoughtfulness weigh into, I don't know, well, what does it really mean for someone to be of this specific racial identity? Who gets in and who doesn't?
And so you're one of the questions that you're asked is why does, at times the Supreme Court seems to be using social science to make a case and to finalize, their reasoning. And on the other hand, they reject it, which is so confusing, especially as it relates to some of the cases that you mentioned that has to do with admission to certain universities, like North Carolina and Harvard and all the others, especially law schools that is so competitive. So why do you think that is happening? If they're pretending as if they're locked in a closet, they have no idea about this racial common, sense knowledge, and pretending as if they're being objective in some of the cases. Why do you think that is happening? And
So
I think that would be your last, because I know you said 1:45 and
yeah, no, I apologize that I'm gonna have to cut it short, but it's a good question. And so I think there's a more cynical way to answer the question and a more generous way to answer the question. And so I'll just offer both responses, because I think it's important that we have a sort of realist look at what could be going on, but also not be overly reductionist. So the cynical answer is that we tend to think of the Supreme Court and the law as somehow separate from politics, that it's just, umpires calling balls and strikes. But I think a different way to think about the Supreme Court and the law more broadly is it is just a different site where politics happens, but often under this veneer of objectivity and neutrality, which actually can make the politics far more violent if the suggestion is that what's happening here is not, it's not partisan based, it's not ideologically motivated, it's just trying to, in some detached way, just, say what the law is, which I think is not the case. But even if you have contexts in which you have Supreme Court justices, for instance, that are like personally invested in being as objective as they can, being as neutral as they can, whatever that might mean, if you have Supreme Court justices who come to the court with sort of deep-seated but not very self-aware assumptions about how the world works, about why the world is the way it is, then if you're someone who, in an unmindful, unthoughtful way, just thinks that certain institutions are dominated by men because men just have, quote unquote, what it takes, it means that you are going to be more likely to rely on some sort of empirical evidence that tends to support that presumption, even if your presumption has no actual basis, because we know that it's human nature to overly rely on any sort of evidence we see that supports our underlying hypotheses about why the world is the way that it is. And so if our underlying hypothesis is that, well, that inequality along racial lines, gender lines, etc., is reasonable for some reason, then even if we're not intentionally motivated by nefarious reasons, we're going to be more sympathetic to evidence that might support that hypothesis. Whereas, which is one reason, or to put it differently, why it's really important for not just Supreme Court justices, but for leaders of institutions and communities to really just force ourselves to ask, well, what is our sort of implicit theory of inequality? Why is it that we think the world looks the way that it does? And what is the basis for that? Is it simply some intuition? Do we actually have something to support it? And the other way to ask the question is, what has the United States ever done concretely that we think would repair our past, that we think would actually be curative or remedial in a sense that we're actually not just sort of stopping harm, even if we had, but actually remedying and repairing everything that preceded us? And if we can't actually identify the steps that we've taken that would create equality, then we should not expect to get it.
That is, some very solid piece of argument, and it's so rich. I mean, we could go so many different ways with what you're sharing, and I know you're putting out the research out there, and it is something for us to digest. Jonathan, I thank you so much. The time went by so fast, and there's so many areas, to talk about this drift that you mentioned, that we could get into, but we're actually grateful and thankful for your time, for what you shared.
Well, I want to thank you so much for inviting me to talk. I hope it was helpful, and I hope we get to have more conversations, whether over Zoom or in person or another time, because it's a pleasure to be here.
Thank you, Jonathan. Take care. Bye-bye.
You too.